Hello, everyone. Welcome to this comprehensive session on Digital Personal Data Protection Act 2023, commonly known as DPDP 2023. I am Dr. Mohit Sajwan, working as an assistant professor in the Department of IT, NSUT, Delhi. And today we are going to explore one of the most significant legislative development in India's digital landscape. Whether you are a student, faculty member, or simply someone who uses digital services, and let's face it, that's all of us, this act directly impacts you. So by the end of this session, you will understand your rights as data principal, the obligation of organizations handling your data, and how this positions India on the global privacy map. So let's begin. So today's session is structured into four key segments. So the first is where we will understand the introduction and background, where why did India need this law and what's the journey that led us here. Second, we will dive into the key provisions. What are the rights you have? What are the obligations on the companies? And what happens if these rules were broken? Third, we will look at how different stakeholders are affected, from educational institutions like NSUT to healthcare providers and e-commerce platforms. And finally, we will walk through real cases studies to see how these principles apply in practices. These practical examples will help solidify your understanding of what compliance actually looks like. So let's start with a crucial question. Why did India need this law? Look at these numbers. India has over 75 crore people online. That's more than 850 million internet users. We are second largest internet population in the world, with the Digital India initiative UPI transaction exceeding 10 billion per month and Aadhaar covering 1.3 billion people. We have become one of the most digitally connected nations globally. But with great digitization comes great responsibility and great risk. So, India has experienced numerous high profile data breaches affecting millions of citizens, from healthcare data leaks to financial information being compromised. These incidents highlighted a glaring gap in our legal framework. The rapid digitization meant that data was being collected at unprecedented scales, but without clearing rules. So, privacy concerns were mounting as citizens realized that data was being used in ways they never explicitly agreed to. So global standards like European Union's GDPR were setting benchmark and India is needed to align while considering our unique context. So the Supreme Court's landmark Puttaswamy's judgment in 2017 recognized privacy as a fundamental right under Article 21. This created a constitutional imperative for data protection legislation, and DPDP 2023 is India's answer to this need. So, balancing innovation with individual rights, economic growth with data protection. So, the journey of DPDP 2023 is fascinating. In 2017, the Justice B.N. Sri Krishna Committee was formed to draft India's first comprehensive data protection framework. So, after extensive consultation, the Personal Data Protection Bill was introduced in 2019. However, the bill faced significant criticism for being too complex with 98 sections spanning over 100 pages. Many felt it was overly bureaucratic and would stifle innovation. So in August 2022, the government withdrew this bill, that particular bill, and announced a fresh and simplified approach. So by November 2022, a new draft, the Digital Personal Data Protection Bill, was released for public consultation. It was remarkably concise, just 30 pages with simple language. After incorporating feedback and parliamentary scrutiny, the bill was passed by both houses of parliament and received presidential assent on August 11, 2023. So, what's important to note in that while the act is now law, actual implementation depends on the rules to be notified by the government. So these rules will provide operational details and we are expecting them to release progressively through our this year 2026 and beyond. So before we'll go through further, let's understand some terminology. The Act uses specific terms that are crucial to understand your rights and obligations. So first one is your data principle. So that's you. Any individual whose personal data is being processed, if you have ever created an account, either on online, used an app, or filled out a form, you are a data principal, data fiduciary. If there is any organization or entity that determines the purpose and means of processing your data. Think of companies like Flipkart, Swiggy, your bank, even NSUT. When it processes student data, they are fiduciary because they decide why and how to use your information. The word fiduciary is deliberately chosen because it implies position of trust. Third one is data processor. These are the entities that process data on behalf of the fiduciary. For example, if a company uses AWS or Amazon Web Services to store data, then AWS is the processor. While the company remains the fiduciary, the processor acts under instructions. Personal data. Any data that can identify you and relate to you. This include obvious things like your name and phone number, but also less obvious identifiers like IP, address, device ID, or even your browsing patterns if they can be linked back to you. Processing. This is a broad term covering any operation on data, collection, storage, use, sharing, modification, or even deletion. Basically, anything you do with personal data is processing. Consent. This is just, this is not just clicking, I agree. So under DPDP 2023, consent must be free, specific, informed, unambiguous, and clearly indicative of your wishes. It must also be as easy to withdraw as it was to give. Now, who does this law apply to? The territorial scope is quite broad. First, it applies to the processing of digital personal data within India. So whether you are a startup in Bangalore or a multinational's Indian office, if you are processing digital personal data of Indians within Indian territory, you are covered. Second, and that is crucial, it also applies to processing outside India if you are offering goods or services to Indian data principles. So, if you are a company based in Singapore but you are targeting Indian users, so DPDP 2023 applies to you. This is similar to GDPR's extraterritorial reach. So, as of for which entities are covered, the list of comprehensive private companies of all sizes, public sectors undertakings, government departments and agencies, startups and SMEs, educational institutions like universities, healthcare providers, basically anyone who processes digital personal data, they are they are basically covered. So there are very limited exemptions, primarily for personal or domestic purposes. So if you are maintaining a personal address book, that's exempt. But the moment you are doing it for any professional, commercial, or organizational purpose, the act applies. One important point, both automated processing using computers and non-automated processing like manual handling of digital records are covered. The key is that the data is digital. Now let's talk about your rights. Perhaps the most empowering part of this legislation, right to information. You have the right to know what data is being collected about you and why. Organizations must provide a clear, accessible notice in simple language and about their data processing activities. So, this notice should be available in English and scheduled Indian languages. Right to access. So you can request a summary of your personal data and details about how it is being processed. Organization must respond within a prescribed timeline. Imagine you want to see what information Swiggy has about you. You have the legal right to ask and receive that information. Third one is right to correction. You found an error in your data. Maybe, suppose your address is incorrect or your date of birth is wrong. So you have the right to get it corrected. Data fiduciary must update or complete your data based on your request. Right to erasure. So, under certain conditions, you can request deletion of your personal data if the purpose for which it was collected is complete, and if you withdraw consent or if retention is no longer necessary, you can ask for your data to be erased. This is often called as right to be forgotten. Though it is not absolute, there are legal exceptions. Right to grievance redressal. So if you believe your rights have been violated, you have the right to lodge a complaint. First, with the organization's data protection officer, and if satisfied, with the Data Protection Board of India. Right to nominate. So this is unique. You can nominate another person to exercise your data rights in case of your death or incapacity. This ensures your digital legacy can be managed according to your wishes. So these are not just theoretical rights, right? So they come with enforcement mechanism and penalties if organization do not comply. Now let's flip the coin. What are organizations required to do? First is lawful processing. Data fiduciary can only process data for lawful purposes or with a legal basis, whether either consent from you or under specified grounds like legal compliance, medical emergencies, or state function. Notice and transparency. Before collecting your data, organization must provide clear notice. This notice should explain what data is being collected, why, how long it will be retained, and with whom it will be shared. And remember, this must be in clear language, not buried in 50 language of legal jargon. Data security. Fiduciaries must implement reasonable security safeguards to prevent breaches. This include technical measures like encryption and organizational measures like access control. Reasonable will depend on the nature and sensitivity of the data. Banking data requires stronger protection than newsletter subscription. Breach notification. If a data breach occur, organization must notify both the data protection board and affected individual promptly. The timeline and the format will be prescribed by rules, but the principle is clear transparency when things go wrong. Data retention and erasure. You cannot keep data forever. Once the purpose is achieved and there is legal requirements to retain it, the data must be deleted. Organization need clear retention policies. For example, we keep transaction record for 7 years for tax purposes, then delete them. Grievances redressal mechanism. Every data fiduciary must establish a system to address complaints. Larger fiduciary called significant data fiduciary must appoint a data protection officer who serve as the point of contact for data principal and the board. These obligations create a culture of accountability. The message is clear. If you are processing people's data, you have serious responsibility. Consent is the cornerstone of DPDP 2023. So let's understand what valid consent actually means. Valid consent must be free, given voluntarily without coercion or pressure. You cannot say, if you don't give consent, we will deny your service for non essential purposes. It must be specific. So, for a particular clearly stated purpose, blanket consent for any purpose we deem fit doesn't work. So, it must be informed. You must be told what you are consenting to in clear terms. Hidden clauses or vague statements do not constitute informed consent. It must be unambiguous, clearly indicating your wishes through an affirmative actions. Pre-checked boxes do not count. Silence is not consent. Inactivity is not a consent. And crucially, consent must be as easier to withdraw as it to give. So if giving consent was a one-click process, so withdrawing it should be equally simple. You should not have to write emails or call customer service to withdraw consent. So now, are these there situations where data can be processed without consent? Yes. Act recognizes certain legitimate grounds. First is state functions like national security or public order, compliance with court orders or legal obligations, medical emergencies where getting consent is not feasible, employment purpose under employment law, reasonable purposes that the government may notify. However, these exceptions are narrowly defined. The default principle remain get consent unless you have a valid legal basis not to. So, what's explicitly invalid? Pre-checked boxes that you have to uncheck. Building consent with service denial for non-essential purposes, using confusing or unclear languages, processing children's data without parental consent. These practices, common until now, are now illegal. The Act provides special enhanced protection for child, and it is one of the strongest part of the legislation. So under DPDP 2023, a child is defined as anyone below 18 years of age. So this is higher than many international standards. GDPR uses 16, US laws often uses 13. So India has chosen 18, aligning with age of majority. So for processing children's data of verifying verifiable parental consent is mandatory. So this means companies must implement age verification mechanism and then obtain consent from a parent or a legal guardian before processing any child's data. So behavioral monitoring or tracking children is prohibited. So this target practices like building detailed profile of children's online behavior, which has been controversially globally. Targeting advertising to children is explicitly banned. So companies cannot use children's data to serve them personalized advertisements. So this is a significant shift for the digital advertising industry. Why such strong protections? Children are vulnerable. They may not fully understand the implications of sharing their data, so they are susceptible to manipulation. Protecting children's digital right is protecting their future. So this has major implication for platform popular with young YouTubers or young users, Instagram, YouTube, gaming apps, ad tech platforms. So they must know, implement robust age verification, obtain parental consent, and fundamentally change how they interact with undergo users. Every good law needs strong enforcement, and that's where the Data Protection Board of India comes in. The board is established under Section 18 of the Act as an independent regulatory body, and it is composed of a chairman and a member of appointed by the central government, with qualification and tenure to be prescribed by rules. So the board has extensive power. It can educate complaints from data principals. So if you feel your rights have been violated and the companies has not addressed it, you can approach the board. It has the power to impose significant financial penalties for violation. So we will discuss amounts shortly, but they can go up to 250 crore rupees. It can conduct inquiries and investigation into data breaches, systematic violation, and complaints. So it can summon information requires audit and inspect the premises if needed. It can also issue direction for compliance, like for ordering companies to stop certain practices, implement specific measures, or remedy violations. And importantly, it provides guidance and clarification as an organization navigate this new regime. The board will issue standard best practices and interpretations. So think of the board as a combination of a court, a regulator, and a guide. So it educates, disputes, enforces the law, and helps the compliance. So the board is expected to be functional, once the rules are notified, and it will play a crucial role in shaping India's data protection landscape. Now let's talk consequences. What happen if you violate 20 DPDP 2023? The penalty structure is significant and designed to ensure compliance. The maximum penalty is up to 250 crores. So this is for the most serious violation, data breaches resulting from failure to implement security safeguards, processing data without lawful basis, and non-compliance with Data Protection Board order. So specifically for children's data violation, the penalty can go up to 200 crores. So processing children's data without parental consent, targeting advertising to minors, or behavioral tracking can invite this level of penalty. So, for general non-compliances with Act provision, penalties can go up to 50 crore rupees. Failure to notify data breach can result in penalty up to 150 crores. Not honoring data principal rights or failing to provide notices can result in penalties up to 50 crore rupees. So here is an interesting provision that data principals can also be penalized if you provide false information or file frivolous complaints. So you can be fined up to 10,000 rupees per complaint, and this prevents misuse of the system. All right. So how does this compare internationally? All right. So let's also talk about cross-border data transfer. So one of the most debated aspects during drafting was data localization, whether India data must be stored only in India. The final act takes a pragmatic approach. DPDP does not mandate data localization, so personal data can be transferred outside. This is a significant departure from earlier drafts that had strict localization requirements, and it is welcomed by the technology industry. However, there are conditions. Data can be transferred to countries or territories notified by the central government as having adequate data protection standard. So think of it as like GDPR's advocacy decision. So certain jurisdictions will be on an approved list. So transfer can also happen with adequate your contractual safeguards. So even if a country is not on the approved list, you can still transfer data if you have contracts ensuring the data will be protected according to the DPDP standards. Importantly, the Act makes clear that overseas entities processing Indian data must comply with DPDP 2023. So you cannot escape Indian law by storing data board. So if you are targeting Indian users, Indian law applies. And data fiduciaries remain accountable. So even if you have transferred your data to a processor abroad, you are still responsible for any what your violation. So for a business perspective, this is huge. Indian startups can now use AWS, Google Cloud, Microsoft Azure without mandatory Indian data centers. So global companies can integrate their systems. This facilitates innovation while maintaining protecting through legal mechanism rather than geographic restrictions. So now let's talk about two case study. So here we are going to discuss about two case study, out of which our first case study is a hypothetical one, while the second one is a real case study. So in the first case study of an online shopping app, so Shop Easy collects basically extensive user data, for example, name, address, phone number, email, payment information, purchase history, a browsing pattern, wish list, product reviews, and more. So, millions of the Indians shop on such platforms daily. So, what must Shop Easy do to comply? First, implement clear, unbundled consent. So when you sign up, you give consent for processing data necessary for transaction that's tied to the service. But for marketing purposes, sending promotional emails, sharing data with partners for recommendations, that requires a separate optional consent. So you should be able to refuse marketing consent and still shop. Second, provide a comprehensive privacy notice in multiple language, not just English but Hindi and regional languages. This notice must explain what data is collected, why, how long it is kept, who it is shared with, and how can you exercise your rights. So third, practice data minimization. Do they really need your date of birth to deliver a product? Probably not. So collect only what's necessary for data stated purpose. Fourth one is your implement robust security. So encryption of payment data, access controls. So not every employees can see customers' information, regular security audits and intrusion detection systems. Fifth one is honor user right. So if customer request their data, so provide it with the prescribed timeline. If they want to delete their account and data, comply unless there is a legal reason to retain it. So like ongoing fraud investigation or tax record requirements. Six, have clear retention policies. We keep your transaction record for 7 years as per tax laws, after which they are permanently deleted. Your browsing history is capped for 6 months for service improvements. So, what should Shop Easy not do? Do not use pre-checked boxes for marketing concept. Do not bundle consent saying you must consent to do everything or we do not let you shop. Do not share any user data with third party advertisers without explicit consent. Do not retain data indefinitely without justification. Do not ignore deletion request. And critically, if there is a data breach, say a hack exposing customer details, do not hide it. Notify the board and affected user immediately. So organization that get this right do not avoid penalties. They build trust. Users are more likely to transact with platforms they trust. So compliances becomes a competitive advantage. Now, in the second case study, which is a real study of a star health data breach, which had happened in the year 2024. So, this case illustrates the high stake of data protection in digital age and how DPDP Act would change the outcome for both the company and the customers. So the incident was the late 2024. A hacker using an alias Zenzen claimed that they have stolen 7.24 terabytes of sensitive data from Star Health and Allied Insurance. And how many victims are there? The 31 million customers. They had their private information and they have entirely exposed. So what was leaked? Leaked their full names, mobile number, home addresses, even their sensitive personal data like PAN card details, Aadhaar numbers, and highly confidential medical history and diagnostic reports. So basically, how it happened? The hacker reportedly used Telegram bots to make the data searchable, so anyone can could enter a phone number and see a person's entire medical and insurance history. So the hacker even alleged that the company's own security leadership was also involved, though the company denied this. So, why the DPD Act is a game changer? So, here in this particular table, you guys can easily see that before DPD Act under ITT, earlier they were under this 2000. So now under 2023 Act, you can see a drastic differences. Earlier it was low penalties, now there are hefty penalties. Similarly, weak notification, mandatory reporting, wake. So these are the following differences through which we can say that now DPDP 2023 is a real game changer. Now let's compare DPDP 2023 versus the global standard. So as if we'll go through the entire table and if we'll compare our DPDP with GDPR of European Union and CCP and CPRA of California, so few things we can take as a key takeaway that DPDP 2023 is more business friendly than GDPR while maintaining strong user right. And that brings us to the end of this presentation. I hope have a solid understanding of the Digital Personal Data Protection Act 2023, what it is, why it matters, and how it affects you, whether as an individual, a student, a faculty member, or a future entrepreneur. For those who wanted to dive deeper, I recommend visiting the Ministry of Electronics and Information Technology website, whether you can access the full text of the acts. It is surprisingly readable at just 39 to 41 sections. Keep an eye on official notification as rules are issued. Those will provide the operational details we need. Remember, this is a living law. The Data Protection Board is yet to be fully constituted. Rules are being drafted. Implementation will be progressive. We are at the beginning of India's data protection journey, not at the end. As a student and faculty of institutions like NSUT, you have a special role. You are the next generation of technologists, entrepreneur, policymaker. Understanding data protection is not just about compliances, it is about building a digital future that respects humanity, dignity, and individual right. I encourage you to think critically about these issues. How can technology serve privacy rather than threaten it? How can innovation coexist with protection? How can India be a leader in both digital economy and digital rights? These are the questions your generation will answer. Thank you for your attention. Let's build a digital India that's not just advanced, but also just equitable and respectful for every individual's fundamental right to privacy. Thank you.